Hello everyone, this is Shiv, a legal intern at LEXIS and Company, and currently pursuing BLLB honors from Central University of South Bihar. So in this video, I will be further explaining the supervening impossibility. In the first video, I had gone through the introduction part. Then after I had gone through the its meaning of the supervening impossibility. Further, then I had gone through the application of that doctrine under different scenarios, and then after in this chapter, I will be dealing with the when the contract become void on the basis of supervening impossibility, and further then after I will go through the some limits of the doctrine. So let us just start. The contract become void on the basis of supervening or impossibility if certain conditions are satisfied, like the destruction of subject matter, which states as the doctrine applies where the actual and specific subject matter of a contract has ceased to exist. Taylor versus Cadwell best illustrates this point. Then after there is supervening illegality. Performance of contract become impossible if in the manner and at the time complemented ensuring from the change in circumstance. If the legislature passes law after the contract is constructed to deal with the changed situation, which makes the contract frustrated. A company in the India dealing with the exports and imports of dry fruits. A gets into an agreement with B, a supplier of dry fruits in Pakistan. Subsequently, war breaks out between India and Pakistan. As a result, the legislature passes a law thereby making the imports from Pakistan illegal. The contract is frustrated by supervening illegality. Then after there is the third condition, that is death or incapacity of party. When there is the contract that depends on the particular skill of the specific act of the promisor, his death or incapacity terminates the contract. A classic case on this point would be Provision versus Davison, a contract between the plaintiff and the defendant's spouse, that is famous pianist, that she will be performing, that is playing the piano or at a concert organized by the plaintiff on a particular day. On the morning of the said day, she approached the defendant, said that she was ill and will not be playing the piano. The concert had to be postponed, and this was a loss for the plaintiff. The court dismissed the case, stating that she had the option to not play if she was sick to do so. The contract was clearly contingent on the fact that she was well enough to perform. Further, there was a fourth condition, that is intervention of the war. A contract entered into before the war commenced between the citizens of the countries subsequently at war remains suspended during the pendency of war. After the termination of the war, contract revives and may be enforced. Further, there was a fifth condition that deals with the government, administrative or legislative intervention. Contract will be dissolved when by the operation of the legislative or administrative action which strikes the objective or purpose of the contract, thereby changing the fundamental nature of the contract. Thus, where a vendor of land could not complete the sale deed because he was no longer the owner due to a law which came into effect, it was held that the contract has become impossible to perform. Further, there were some exceptions to the doctrine of the prevailing impossibilities, like the difficulty of performance, commercial impossibility, action of a third party, strikes, lockouts, civil disturbance, and riots. Further, there was a partial impossibility. So now let us move to the limits of the doctrine. The norm is that the parties will be held responsible to breach of the obligation under the contract, and the parties getting discharged due to unforeseeable circumstances. Acting in conscience with the approach, the court have made an observation that the change of the circumstances must be such as to append the object of the contract. Some impediment or some deviation is very common in all transactions, and it cannot be assumed that any of the some divisions is very common in all transactions, and it cannot be assumed that any agreement has been made on the implied understanding that such a thing will not take place to any extent. Further, there was commercial hardship or bad bargain. It is an important limit of the doctrine. Davis Contractors Limited versus Farhan UDC perfectly illustrated this point. Further, let us come to the conclusion. The above discussion has shown that the doctrine is by no means easy to apply, especially in regard to the fact that it is an exception to the strict principle of the contractual obligation. Nevertheless, it is an important feature of the English law which occurs when a contract becomes impossible after it has been formed and before it is completed. Bearing in mind that the term impossible has to be understood is not only the physical sense but in a broader and more practical context. It can be concluded that supervening impossibility corresponds to the doctrine of frustration because it includes the same features. In India also there are many events which this doctrine is used. Supervening impossibility makes a contract void. So that's all for now. Let us meet in the next session with a different topic. Thank you.